I'm sure a lot of you have questions, and that it's always helpful for others to hear what your challenges are.
Hey, Rand, I'm working with a client right now that's got a medical product for doctors. Proven, already being used, wonderful product. The challenge is getting time with the doctors to describe it for the, and he said it has a licensing model. What do you do as far as reaching out to doctors? Do you actually do that type of work where you actually approach the doctors and close the sale and everything?
Well, not so much the doctors if they're the end buyer.
Or the users, yeah.
Okay, my role is one of reaching out to the companies that are going to manufacture, produce, distribute, and sell it. So I wouldn't be involved in the end customer as much as reaching out to the companies that would eventually reach the end customer, such as the doctors. That's why you would license it. They have the people to handle it.
I have a question, and let's go to Austin. You mentioned prior art. What does that cost when someone to do that search and to come up with prior art information?
Okay, so the basic, at least with my firm, typically it costs the client between $1,000 to $1,200 out the door for a prior art search and a discussion about whether or not I still think you can get a patent.
Is that before the 10% med tech discount?
Most of that actually goes to a search firm. If I were to do the searching myself, it would cost too much money. So there are basically a search firm in Bethesda, or in Maryland that I use, that's basically full of ex-patent examiners. And they just stayed in the searching area, and therefore it's just much more cost efficient to get that done.
Which leads to my follow-up. So can you summarize what does it cost to get a patent? If you could say patents generally cost X.
Okay, so basically, remember the three phases: patent prosecution, prior art search. That phase is basically, like I said, between $1,000 to $1,200 for my clients. The application writing phase, that can vary. Obviously, you have a lot of different technologies and the amount of detail that you have to get in. For my clients, it's typically $5,500 to $9,000, and that's out the door price. That includes my time, the draftsman's time to actually do the drawings for you, and the USPTO fees. If there's some ways to save you money and all that stuff, like if you already have some drawings that we can cannibalize and turn into patent, it will cost less. Prosecution phase, that's the big unknown. We never know what the patent office is going to come back with. If they send you, I had a response recently, it was 45 pages long. When I get a 45-page response, it typically means I have to write a 60-page reply. And therefore, that's going to cost more and that kind of stuff. So unfortunately, when you get to the prosecution phase, there's too many variables in there. But if you have to deal with one office action, then you get an allowance, you're typically looking at another $3,000.
So as far as time, which is going to be the follow-up to that, is the time to get a patent on average, would you say it takes X to get a patent?
I would say typically around, to get someone to look at it, you're looking at 2 years, 2.5 years from start to finish. Sometimes you can get a first action issue and it's great. Sometimes the examiners will go through their docket and find your patent, pull it out and allow it, which is great. But most of the time you're looking at 2 to 3 years.
Now, we've all seen Shark Tank, alternative questions, and, you know, when they make licensing deals and these deals in 15 minutes, and I applied for my patent. You know, to apply for the patent, can I sell during that time?
You should be selling. Once you get a patent application filed with the patent office, you put your place in line, and now you should go out and exploit your invention right away.
I'll get it.
No, it's not. So basically, you should try and make money as soon as you get it on file at the patent office.
So do you call it patent pending at that point in time?
You sure do.
And you
Right away.
label it accordingly?
Yes. There is no power to patent pending, though. All it is just a notice to people and stuff like that, I believe.
You may want to expand on expedited patents.
Yeah, you can expedite patents.
It's significant.
It is, but I think it's 15.
It's $1,000, $2,000 depending, and they by law have to give you, I think, 60 days.
Yeah.
We do that all the
Oh,
time.
you do? Okay, yeah.
And the age of the applicant.
I do that, yeah, the age of the applicant.
By
Yes.
trying to license too early, don't you risk having your patent not granted, and then you I mean, the companies are not going to be happy.
So if you basically license and then your patent falls through, how does that work?
Or,
that-
or what happens more often, I mean, almost all the patents, you can get something out of it, but
Right.
then sometimes you have to collapse everything in one claim, and that makes the whole thing very weak, right? Right? So when you have only one solid claim, then it's probably not such a good deal for the first company that believed in you. So are you in a pickle there?
Well, you can license patent pending, obviously, that impacts the deal, subject to getting the license. And these companies, you know, you go to these large companies, the first thing they do is search the patent database. I mean, they go to their legal department, they'll search it, they'll evaluate your patent, they'll determine, you know, how strong it is, how valid it is. If they like the technology, they'll continue to investigate it, but at some point, they will actually go in, bring their IP counsel in, they'll do a freedom to operate search. They'll want to make sure that there's no
So basically,
potential
what
liability
you're
out there.
saying is that if they do their homework, they take the risk.
Well, I mean, any company that is serious about it is going to do their, but before they sign the deal, they're going to do their homework on the patent anyway. Because that patent obviously is what gives them the competitive advantage, but it's also something, keep in mind when you sign a license agreement, part of an agreement is that they can take on the infringement actions, if there are infringement actions. So obviously, they're going to want to research that and determine whether or not there's any potential time bombs out there, okay, which there can be. It's not that they can necessarily find it, because as you know, I mean, there's millions and millions of claims. It's very difficult and challenging, but they have to feel reasonably confident that they've got an area to operate, a freedom to operate in.
Yeah, and that's the one thing. Typically, like if your patent starts making money, someone's going to want to get in there.
Right.
And one of the first things they're going to do, if they're really into it, is do a worldwide patent search. I had a client who had been exercising their patent for about 5 years. Someone came into their space and then found prior art in Korea. Torpedoed their patent, torpedoed their business. It's a risky endeavor. So.
What does a typical license agreement look like?
Well, there's not really any typical license agreement. It's just, there's so many variations. It depends on the IP, the technology, the market, the status of the technology, who you're going into. I mean, it varies. Rule of thumb, if you're, about the only thing I could tell you in a license agreement, rule of thumb, 5% royalty rate, give or take, for just about any technology. But beyond that, every license agreement is going to be different.
And in the ballpark that you give 5% is exclusive, we understand.
Depends.
It just depends.
Oh,
It depends. And you have to be careful with exclusivity. There's exclusives and there's exclusives. It can be exclusive to territory. I mean, I'll give you an example. I was working on a deal for a client of mine, one of the largest pharmaceutical companies in the world. It's for the oral healthcare technology. And they started talking to us about exclusives. So the discussion was, well, where are you going to start selling this? It turns out they were going to start with the UK and Germany. So the exclusivity that they wanted was going to be granted only for where they're going to start selling. Okay, and that's what I mean about exclusivity. Giving them worldwide rights when they're not going to exploit any other territory is just basically losing money, throwing money away. So you have to be very careful with that and allow them, that's what I mean when I said earlier on, to earn it out. Licensing agreements are performance-based. It's always got to be performance-based. That's how you can protect yourself.
My experience in dealing about 50 years of patents in every technology has been picking the right attorney. And most people don't understand, and in technical especially, you need somebody, if you're in biomedical versus device versus electronic, if they don't have that background, that extra EE or PhD behind their, you know, in my experience, you'll wind up writing the patent yourself with someone because they won't even understand what you're trying to do.
Right. I mean,
Same as-
when you're like in the deep
Yeah,
sciences,
yeah.
yes. And in fact, in bio, most of the time, the people you're going to work with are patent agents.
Yeah.
because they've already gotten their PhDs, and they're like, I'm not spending another 3 years going to law school.
Yeah.
So they sit for the patent bar exam, and at that point, in a lot of those fields, your best people in there are actually patent agents and not patent attorneys. Patent agent can do anything before the patent office that a patent attorney can do. So, except they can't do your assignments or
Yeah.
outside
Litigation.
Yeah.
So I have a question. So the licensing is here for the United States, and I can see that as great protection for anybody with a patent originating from the United States. What protection is there for them once they've submitted that patent, that it doesn't get converted worldwide somewhere else? I mean, is there any type of surveillance to make sure that that patent is not being used somewhere else in the world?
Well, the thing is that, okay, so you can file what's called a PCT, which is Patent Cooperation Treaty application. It's kind of expensive, and then that gives you an extra 2.5 years. So basically, you file a patent application, provisional or non-provisional. Within that year, you have to file in all the foreign countries that you want to file in, or file the PCT, which gives you an extra 2.5 years to file in all those countries. And all those countries have agreed to give you the initial filing date over here in the US. So basically, everyone will treat that you filed everywhere in the world on the date that you filed inside the United
Oh,
States.
that's awesome.
Yeah, it is, but it gets real expensive, like a European,
I'm sure.
and you got to know that ahead of time too, because filing a European patent, the rules are much different, and you have the same disclosure. So if you're more US based, your patent's going to read differently than if you know that you're going to go into someplace like Europe, which is very stringent in their patents.
Another, I'll get to your, just want to follow-up comment here, and then to your question. Another opportunity that exists in licensing, and it has to do with going international if you're US-based. Licensing these larger companies, especially if you're going to file a PCT, you can have use it to your advantage, because many times as part of the license, if you have that window of opportunity to file it, that can be part of the negotiation where those companies will come in and actually help file that for you. It's in their best interest, especially if they're going to be exploiting those markets internationally. They'll also act as a monitor as well. There's nothing better than a big partner to monitor the world for you.
Yeah,
So
absolutely.
my question is, are those license agreements usually without time limit, or is there?
There's always, I would recommend, there's always a time limit on a license agreement. Generally, if it's around a patent, it's the life of the patent, although that can be extended if you've got trade secrets and know-how in there, which is often the case. But you always want to have a time limit on that and most companies are going to want a time limit usually based around the patent as well.
Assume I'm a patent holder and I've successfully got my patent, right? And somebody is coming after me and it's frivolous. Is there any obligation that I have to defend that patent? Because I've heard that there is, and I don't know if that's true or not. So if it's just like frivolous lawsuits, like the patent trolls, guys like that. What's the obligation that I have to defend it?
If you get called into court, you have to go.
Okay?
It's regardless. And
There's no option.
so it almost sounds, let me rephrase your question. It sounds like what you're saying is, okay, if you're being sued and you get a subpoena, you have to go.
Right.
As an attorney, I'm telling you, always go, because you'll get a default judgment and you lose.
Sure.
And they could be like, it's frivolous.
I think this would be a good point. Can you explain the difference in securing patent rights versus a trademark and copyright as it relates to infringement? Because I think a lot of people are a little not as clear on the difference between those two.
Okay, so the idea being is that in a patent, if you've ever read a patent, there's the specification, the drawings, and then the claims. The claims are just like out in the West. You used to make a claim in land. These are the four corners of my property. You cannot step on it. So when you're dealing with patents, you have to almost read your claims like a checklist. Do they have element A? Do they have element B? Do they have element C? If so, they're infringing, even if they have more elements. But they just have to have the basis of the elements that you have. Trademarks, you go after them and you're like, first you ask them to cease and desist, then you go after them for likelihood of confusion. Now, are you talking about blatant?
No, I'm talking about the issue as it relates to, with a patent, it's a negative right where you have to
Use it
sue
or lose
them to prove the infringement versus a trademark where they have to prove that they didn't infringe on.
That's the litigation stuff.
Right.
I'm more of the patent prosecution side. But yes, when you go into patents, the part of the reason, a negative right, you have a patent, doesn't mean that you can go out and make it. Because if someone previously has a patent on A plus B, and your invention is A plus B plus C, C makes it the greatest thing in the world. The patent office is happy, they're like, great, here's your patent. But if someone has a pending patent on A plus B, and you can't make your invention without it, you're infringing their patent. So the patent is a negative right. You are only allowed to prevent others from making, using, or selling your claimed invention inside the United States. That's it.
The reason I ask my question is what I'm seeing a lot now is these patent, what I call patent trolls,
Trolls.
right? And a lot of us in here are small businesses. So is there any strategy to prevent that, you know, that you just get beat up by the cost of litigation? Is there any way to defend, whether there's any strategy to do that, or, because I'm seeing it a lot.
Unfortunately, it's America and everyone has a right to sue.
The patent troll issue,
Problem.
from what my experience in seeing, you know, the patent troll issue comes about anytime there's an industry that's really heated up and there's a lot of activity. And for the medical device, medical technology, patent trolls have set their sights on this industry. It's much like you've read a lot of the patent litigation that's gone on in computers and smartphones. You read about these multi-million, sometimes billion-dollar, and it's because of all of that technology and everybody winds up stepping on their toes. There's a lot at stake and these big guys play in it. Unfortunately for the small guys, they get caught up in it. A lot of times their patents get infringed on and you have really no choice. One is to basically work with these trolls, these litigation firms, and just take whatever you can get in recovery. But with that said, if you can see what's going on in the landscape, this is where, again, licensing can be a strategy. And I've spoken about this before, the medical device and technology industry is going to be a patent troll. There's going to be a patent troll issue. It's coming, it's been identified, it's been in the news the last couple of years, so it's coming down. And you have to be prepared for it. And one of the ways you can do that is through licensing, because when you license a bigger company, they're prepared for it. They've got lawyers on staff, they've got huge financial resources behind them, and they can handle those patent trolls. Small businesses can't handle it because their business is about forcing you into litigation and then forcing you to pay.
Fran, does it happen that you get, and then, like, say I'm the creator and I own the IP, is there ever a situation when you license where I ask the person, you know, licensing the product from me to indemnify me?
Yeah, all the time.
Really?
That's part of it.
Okay.
Yeah, absolutely. And there's actually a step further that you can go as a small business, and I don't know how many people are aware of it, but you can actually get insurance against patent litigation. You can insure your IP for patent claim, patent infringement, both against you and for you taking action against another company. It's very specialized insurance. It's offered by some very large firms. It's specifically for that, to handle that. But inside of a license agreement, part of that is an indemnification where your partner is going to take on. And it's used quite a bit. I mean, it's a smart thing to do, is to allow the partner to take the legal action.
Brand, doesn't licensing your patent give it additional validity?
Well, it does if it's in the, sure, and they're making and selling it and generating revenues with it, the value of your patent is going to go way up.
That doesn't strengthen it from a legal standpoint?
No, it shouldn't. I mean, prior art is prior art.
Yeah.
And, yeah, but what he's saying is now you have big bucks behind you.
Right. You have,
Mike makes right.
you had the big bucks because, and Austin touched on this, but for a lot of small businesses, I mean, once you get the patent, one thing that isn't done a lot is what's called the freedom to operate. That's where you go out and you find out everything that's out there, so you can find out if you really can use your patent to the extent that you want to. And that's the place that you can wind up getting tripped up when you discover that, you know, A and B is about to come out, and your A, B, and C isn't going to work. But again, this is where the big companies have the advantage because they've got the resources and the legal muscle to handle that.
Austin, would you mind elaborating a little on what you mentioned about the times? You know, what happens when your patent gets too long in being granted? You know, do I need to request that? What is a reasonable time, or how?
It's an automatic thing. So basically, the patent office, when they switched from 17 years from the date of issue to 20 years from the date of filing to be the lifetime of your patent, the compromise was there that the patent office, and I'm not sure the exact time, has to work within certain time frames. And if they don't, every time they take too long, that term gets added to the end of your patent once it issues. So it's supposed to be 20 years from the date of filing, but it can be 25 years, or something like that.
And the patent office decides that?
Yes, it's a patent term adjustment. You can argue it and go back and forth during the litigation time. Mainly in the pharmaceutical business, that's where these guys go head to toe with them, so.
Let's jump into
So with trademarks, is it also, let's say a name of a company's shares of word in common
Speak up.
with, is it determined by first in use, or is it,
In trademarks, first in use always wins.
I'm sorry?
First in use always wins,
Oh,
with caveats. But for the most part, first in use always wins.
does it matter if the second in use has
Much.
50 times more use?
It does. I mean,
It
they
does.
do get, so you can be like regionally restricted and stuff like this, but typically in trademarks, first in use wins, you know.
I want to thank everybody for coming, and I want to thank Austin and Rand. They will stick around and answer all your questions, but thank you guys very much.